My goal as a lawyer was to become a crown prosecutor. I wanted to work in the public sector. I made a master's degree in law for the only purpose to become a crown prosecutor. But 2 months before the end of my master's, there was the announcement that the bill became a law. So I wasn't able, from this moment, I wasn't able to become a crown prosecutor, to work in the government as a lawyer, as a clerk, as whatever. I couldn't. And when this happened, I was forced to work in the private field because I can't work in the public field if I have a hijab, if I wear a religious symbol.
Since Bill 21 became a law in the summer of 2019, lawyers, teachers, bus drivers, and public servants of any kind wearing a religious symbol, including but not limited to the hijab, niqab, turban, and kippah, are barred from working in a government job unless they remove it. Noor Farhat is a lawyer in Quebec who is not only affected by the secular law, but is also representing the Autonomous Federation of Education, a plaintiff in the lawsuit against Law 21.
It's about lawyers, it's about police officers, it's also about teachers. The biggest population that is concerned and affected by Bill 21 are the teachers. There is a lot of teachers who wear religious symbols. Bill 21 is not only affecting people who are already in the workplace, it's affecting students. It's making a big pause in the life of everyone that is concerned, everyone who wears a religious symbol.
Ultimately, this law contradicts freedom of religion in Section 2 of the Canadian Charter of Rights and Freedoms. McGill Dean Robert Leckie explains how the notwithstanding clause is used to work around the Canadian Charter.
The Canadian Charter of Rights and Freedoms is unusual in that while it guarantees a whole set of fundamental liberties and rights, it also gives the legislature or parliament the possibility of kind of derogating or accepting from those guarantees. So the charter has its section 33, which allows a legislature to state that its law is going to operate despite or notwithstanding fundamental rights. And so the legislature essentially gets to decide that one or more laws are going to be immune from being struck down by a court for chunks of up to 5 years at a time.
In this episode of Local 514, we'll look at the history of Law 21 and just how far the Quebec government can use the notwithstanding clause to use Law 21 in Quebec.
So the notwithstanding clause has been used more often in Quebec than anywhere else. And it was most famously used, I think, to protect Quebec's Charter of the French Language, or Bill 101. So for some time in the 1980s, the Charter of the French Language limited freedom of expression by requiring that French be the only language used in some commercial contexts. And the Quebec legislature had protected that law with the Charter's notwithstanding clause. And when the 5-year use of the notwithstanding clause lapsed, parts of Bill 101 were then struck down by the Supreme Court of Canada.
Following the adoption of Law 21 in 2019, there was a court hearing that summer to allow public opinion on Law 21 to be presented in front of the court. In November 2020, the trial for Law 21 started, lasting 7 weeks. The results of this trial will decide whether or not the law is constitutional. Some groups and one person have filed a lawsuit against the Quebec government for enacting Law 21. Currently, the public is waiting for the judgment from Justice Marc-André Blanchard. This could be released any day now or within the next few months. Diane Rolla, president for the Coalition Inclusion Quebec, explains what will happen after Blanchard's decision.
Whether he finds in favor of us, of those who are opposing the law, or whether it finds in favor of the Quebec government, either way, either party is going to appeal. And then after the Court of Appeal, depending on who wins or who loses, it's pretty much expected that the next thing would be to ask for permission from the Supreme Court to hear the case, to hear an appeal. And if that happens, then whatever the Supreme Court decides, it's going to make constitutional history.
Of course, the Canadian Charter isn't the only resource in the Canadian Constitution. And so even when the notwithstanding clause is used, there are other bases on which something can be attacked from within constitutional law. And so the judge heard from a number of groups this fall arguments that Bill 21 should not be allowed to operate, to have its effects, despite being protected by the notwithstanding clause. Some of the arguments were based on federalism, the idea that what it was doing was something only Parliament could do and not a provincial legislature. There were really a range of challenges, but the federal government could have intervened in that trial if it wished to do so. And the federal government still could intervene in the proceedings if they move next to the Quebec Court of Appeal or eventually to the Supreme Court of Canada.
So to what extent can the notwithstanding clause be used? While Law 21 only applies to government jobs, if the Quebec government wishes to, they can apply Law 21 to private businesses.
Where I see a precedent that concerns me is that the provincial government, in using the notwithstanding clause to protect Bill 21, didn't explain carefully why it was necessary and why it was nonetheless taking into account the perspective of the minority groups affected. Instead, it just said that the public wants this, we have a majority government, and in a sense, it doesn't matter if our legislation tramples on individual freedoms. And if that's the kind of attitude that's going to be used in future cases, one can imagine other very unpleasant consequences as well.
Discussions of this law can be focused around secularism, which is separation from the state and religious institutions. This is not new in Quebec, as Quebec has a long history with secularism. Bill 62, which banned those with face coverings from delivering and receiving public services, was put into effect in 2017 by the former provincial Liberal government. This law was suspended twice as a result of being in violation of the Quebec and Canadian charters. The former government did not decide to appeal this judgment or use the notwithstanding clause to push for Bill 62. Premier François Legault and some supporters aim to identify that Bill 21 does not target specific religions, but is the next step in modernizing the province, efforts that have been put in place since the 1960s.
C'est un outil légitime qui a déjà été utilisé par René Lévesque et par Robert Bourassa. Au Québec, ça fait longtemps qu'on a décidé de séparer la religion et l'État, et ça fait plus de 10 ans qu'on débat des signes religieux. Il est temps de fixer des règles parce qu'au Québec, c'est comme ça qu'on vit.
While discussions of Law 21 focus on secularism, some say the law is much more than having the ability to wear a religious symbol, including community activist Ihab Lutaif.
From Legault, yes, right here in Quebec.
It calls itself about that it's about religious symbols, but it really is about the core belief of some people in particular, because they believe that dressing in a certain way is a part of their religious duties, a part of their understanding of their religion.
Several hundred protesters have turned out for previous anti-law demonstrations and pro-Law 21 demonstrations. Some protests have taken place over Montreal in the last couple of years, from marches on the street to a protest held outside of Premier Legault's Montreal office this past summer.
We have been fighting this law on many grounds. We've been fighting this law on a political level, on a judicial level, and on a public level. There were actions on the grounds. There were actions in the Assemblée Nationale. There were actions in meetings with politicians. There were actions in the courts.
While the destruction of Law 21 would be a victory for many, community activists Ihab and Sarah Ragab outlined that this would not mean that Islamophobia, racism, and systemic racism no longer exist in the province.
I think that the bill or the law is amplifying or validating ideologies or opinions that are already there. I don't think it's creating it. I think, or maybe it is, but I think for the most part, it's kind of like fueling it and amplifying it and making it, giving it a legal, kind of like giving it a legal approval. And it's giving it so much more weight, because whereas before it was like ignorance, now it's like, well, the state is implementing it. While I do think it's amplifying it, I don't think that if the bill just stops or the law just stops existing, that it would stop any of this ideology from occurring.
When we are living under a government that refuses to acknowledge that there is systemic discrimination in the Quebec society, we are having already a huge problem on our hands. And then when a law is out there targeting religious practices of some people, and surely targeting religious practices of some religions more than others, it empowers and emboldens people who have sickness in their heart and who are really discriminatory, racist by their upbringing, by their experiences, whatever it is. It emboldens them to take stronger positions and more public positions, and that is what we have seen, and that is another byproduct of passing such a law.
It's not just something you wear on your head, right? It's a religion. So being told that you have to make that compromise, that like you have to choose between your career and like being an enlightened woman or being an oppressed woman with a religion, you know, like that's kind of like the false binary, and it's a false choice that they're making us choose between.
But until Law 21 is abolished, many will have to make this choice.
It's really a difficult process to actually accept the fact that, oh, I'm not able to become what I've always studied for and what I wanted to do. So now I'm a lawyer in this case, I'm a lawyer in other cases, but I'm not living my dream in Quebec. It's a difficult realization to be affected by a law like this one.